Get ready. 5 seconds to go. Start. Evidence of formal character on affidavit. Stop. The evidence of any person whose evidence is of a normal character may be given by affidavit and may subject to all just exceptions be read in evidence in any injury trial or other proceeding under this code. Stop. A perusal of the above provision shows that the court can act on the affidavits of parties in any inquiry or trial if the evidence to be tendered by any person is of a formal character. Stop. The newly added proviso to section 142 of the act empowers the court to condone the delay in filing a complaint if the complainant satisfies that he had sufficient cause for not making a complaint within the statutory period of limitation. Stop. Therefore, if the statutory requirement is to be satisfied, the complainant who seeks the benefit of the proviso has to necessarily explain the reason for the delay. Stop. The best way to do this is to swear to an affidavit which can be acted upon by the court without the applicant being examined in court under oath. Stop. In the case on hand, the position is slightly curious. Stop. There may not have been any lapses or delay on the part of the complainant in taking steps to file the complaint. Stop. As is relieved from the available materials, the complainant is stated to have entrusted the necessary documents to his counsel for filing the complaint. Stop. But the delay of 2 days had occurred in the office of the counsel, as according to him he had misplaced the records of the case somewhere in the office. Stop. In that view of the matter, there was no impropriety in the counsel himself filing an affidavit stating the reasons for the delay, but the proper course would have been for the complainant himself to file an affidavit stating the reasons for the delay, along with which he could have produced the affidavit of his counsel also. Stop. But this was not done. Stop. Therefore, in my view, the learned magistrate was not justified in condoning the delay on the strength of the affidavit filed by the counsel of the complainant. Stop. The learned magistrate would have been eminently justified in accepting the explanation of the counsel for the complaint. Stop. But the delay could have been condoned only on the strength of the affidavit of the complainant himself. Stop. Learned counsel for respondent number 1 submits that the complainant is prepared to swear to an affidavit and present it before the court. He prays that a direction may be issued to the court below to consider the application in the light of the affidavit that may be filed by the complainant himself in addition to the affidavit of the counsel which is already on record. Stop. In the above facts and circumstances, the impugned order is set aside. Stop. The learned magistrate shall consider the application for condonation of delay afresh if the complainant swears to an affidavit of his own in support of the application. Stop. Learned magistrate shall pass appropriate orders on the application afresh in accordance with law. Stop.